Uh, this meeting is oh God. Good afternoon, everybody. Welcome in this 16th series of Anatomy of Case Laws based on IBC. I would request to please open your video or window or what we can say in Hindi, khidki. We can have interactive session instead one-way traffic. I believe in interactive session. Yeah, thanks Alok ji. Thanks Deepak ji. Thanks Mr. Bas. I would like to have more interactive session than uh, giving one way only lecture. So today we are going to share very important judgments of Honorable Supreme Courts, some judgments of NCLAT also and NCLT also. We will also analyze some legal aspects which are troubling to liquidator while uh, handling this liquidation process. They are facing lots of difficulties, particularly due to pendency of litigations. The liquidation process gets prolonged. The timeline has given 1 year only, whereas the liquidation process prolonged for 2 years, 3 years, 4 years, and is still unknown. We liquidator does not know when this will be finished due to pendency of litigation, different type of litigation related to property, relating to PFA transaction, like that. So first of all, I would like to share one judgment of which is very important of Honorable Supreme Court, which was passed in February 2024. So just a moment. See, this is the I have just prepared this topics and issues related with the judgment. This judgment.
I hope you will share this after post your lecture.
Pardon? Deepak ji, please tell me.
I hope you will or should note down. Like I hope you will share this presentation after your lecture, no? Or we should note down all these particulars.
No, you need not to. I will definitely share. I will definitely share these issues and thereafter judgment
Okay.
also.
Thank you, sir.
Yeah, welcome, most welcome. So this judgment of Supreme Court in the matter of Greater Noida Industrial Development Authority appellant versus Prabjit Singh Soni. Was the RP. He is the RP of GNC Construction Private Limited. Now issues came before this Honorable Supreme Court whether NCLT has recall power. I will just trigger the main issues because instead of touching all subject matters, we will not be able to understand. We will understand by the issues. So what is the power of NCLT? Whether NCLT has a recall power, whether GNIDA operational creditor or secured creditor, operational creditor or secured creditor or operational creditor. Secured financial creditor. I think it's secured financial creditor. Whether using the appropriate form A/B, C, D, E, F as given in the regulation is mandatory. Whether notice of COC meeting was required to be given to GNIDA, Greater Noida Industrial Development Authority. Whether resolution plan approved by the NCLT and upheld by the NCLAT can be sent back to COC for redeciding on resolution plan after due compliance of IBC and its regulation. So these are the issues came before the Honorable Supreme Court while deciding this case. So now I will come to judgment. Now, just this matter was decided by the 3 judges benches. 3 judges, including CJI, Honorable Chief Justice of India. I'll just brief about this matter. What happened? The CIRP of this company was commenced in 2020, just a moment. 30th May 2019. CRP was commenced 30th May 2019. And the resolution plan was passed by Honorable NCLT on 4th August 2020. So the issues came before the Honorable Supreme Court, namely inter alia recall the order, NCLT, whether NCLT has recall power, resume professional treating the appointment of operational cater, not informing the appellant about the meeting. See, the GNIDA was treated as operational cater and he was not informed about the any COC meeting. This is very interesting judgment for all IPs because IP should be more vigilant. IP should be more responsive instead of reactive. So this will definitely help to IPs that law does not help to lazy person. The appellant of being a statutory authority concerned on the, just I will come to the main topic. After this initiation of CIRP on 30th May 2019, public announcement was given, public notice in the public announcement was given, and thereafter this appellant, that is Greater Noida, filed their claim in January 2020, filed and for 43.40 crores. RP treated the appellant as OC, operational cater, via email. RP also acknowledged, that is respondent, that yes, I have received your claim, and he sent a reply on 4th February 2020 and requested the Greater Noida to file their claim form in Form B. The appellant did not submit its claim afresh as an operational cater. In the meantime, the COC approved the resolution plan, was presented to the AA for approval, and white order 4th August 2020, NCLT approved the same. On getting information through letter dated 29 September that plan has been finalized and approved, on 6/10/2020, the appellant, that is Greater Noida, filed an IA 344 before AA, questioning inter alia the resolution plan, the decision of the RP to treat the appellant as OC, and all action in pursuance thereof. Another IA 1380 was filed seeking inter alia recall of the order dated 4th August 2020, recall of the approved resolution plan. In two applications referred, the appellant pleaded that there was a gross error on the part of the RP in treating the appellant as OC, particularly when it had no adjudicating power under Regulation 13, the Insolvency IBBI, CIRP Regulation 13 under CIP regulation. The resolution plan erroneously states that appellant did not submit a claim when in fact it was submitted. See, this is very, very important. This is a clear-cut ignorance on the part of the RP in the resolution plan, that the resolution plan triggers through IM. So in IM, he must have written nil. Greater Noida, the CD owes to Greater Noida 43 point something crore, 43 crore. He has filed this claim before RP in different form instead, and RP has treated his claim as zero in IM.
In spite of the mail received from the authority.
Yes.
Okay.
The resolution plan irrationally states that the appellant did not submit a claim when in fact it was submitted. Appellant, being owner of the land with statutory charges over assets of the CD, ought to have been given top priority for its dues as a secured creditor. No opportunity of hearing was given to the appellant by COC, and the entire process right up to the approval of the plan by AA was ex parte. The resolution plan approved by the COC without inviting to Noida authority. Now, can anybody say that why Noida authority should have been invited in the COC? just I am stopping this sharing. I am just asking, just sharing, just to have interaction with you. Why this Noida authority should have been invited in this COC meeting, being a OC?
Ajay ji, I have a question here. Do you have, information on when was the claim filed? I mean, how many days after the commencement? Was it nearer to the later stage or?
7 after he filed, the Noida authority filed its claim after 6-7 months.
Okay, so that was much later in the process.
Yes.
And what was the total claim size?
43 point something crores.
No,
And
I
the
mean,
total claim.
yeah.
Total claim is about 100 something, 120, 130.
Okay.
It is not mentioned in the order, but I am just because I know these facts, all this. So it is 100 plus.
I think he did have a right to participate at least in this COC.
Reason behind this?
10% का है ना उसमें कि 10%.
Yes. So if any OC having 10% of claim of total claim, he has right to attend the meeting, although he has not right to vote, but he has right to participate. He has right to attend the meeting or supervise the meeting. So participate in the meeting without having voting rights. So now again I am coming to same. So see, Noida authority has challenged this approval of resolution plan. So they filed this application. NCLT wide order, this order 5th April 2021 rejected the aforesaid application on the ground that despite the lapse of 7 months between the date of filing of claim and the date of approval of plan in August 2020, the appellant took no steps against the RP for not taking a decision on its claim, even though it was aware about the initiation of the CRP. And now it is not permissible to take a decision on claim application of the appellant as the CRP is complete consequent to approval of the resolution plan. Even the resolution plan was also implemented. Now appeal before the unclaimed agreed with the order of the NCLT. Appellant filed an appeal before unclaimed. The appellant was a financial creditor and therefore ought to have been a member of the COC. On account of absence of appellant in the COC, the approval of resolution plan by the COC and thereafter by the NCLT is rendered invalid. So he has taken this ground before unclaimed. Now, second ground, by virtue of section 14 of 1976 Act of this Noida Act, the appellant, the appellant had a charge over the assets of the CD and was therefore a secured creditor within the meaning of 330, read with section 331 of IBC, yet the resolution plan does not treat the appellant as secured creditor. Third, the appellant had submitted its claim with proof, yet the appellant was shown as one who submitted no claim. See, RP has shown his claim as no claim in the IM. Additionally, the appellant was neither informed of the meeting of the COC nor adequate amount commensurate to its status as a secured creditor, and the owner of the land with statutory right was allocated to it in the resolution plan, which is violative of the provisions of section 30 subsection 2 of IBC. The NCLT failed to address and appreciate the ground taken in the correct perspective. Now, finding of the unclaimed, the appeal preferred by the appellant was dismissed by observing inter alia. The material on record reflects that the RP had informed the appellant via email 4 February 2020 about its status of the claim as OSC and to submit its claim in Form B. Yet the appellant chose not to file its claim. In New Okhla Development Authority versus Anand Sobhadra, it was held that disbursement is an indispensable requirement to constitute a financial debt within the meaning of section 5, section 8 of IBC. That too, the disbursement must be from a creditor to a debtor, and as the lease executed by the appellant was not a financial lease or capital lease, the appellant does not qualify as a financial creditor. So these are our observation given by the judgment given by the unclaimed. The resolution plan was approved by the executing authority and the successful SRA SR8 seeking implementation of the plan informed the appellant by dated so-and-so 24th September 2020 about the plan. Yet IA was not filed before 6/10/2020 and IA 1380/2021 seeking recall was filed only on 15th March 2020, which shows that the appellant had not been diligent in pursuing its right, if any. Therefore, the challenge post-approval of the resolution plan is liable to be rejected. There appears no material irregularity in the approval of the resolution plan, particularly when the commercial wisdom of the COC is not justiciable. We have heard Sri Ravindra Kumar, learned senior counsel for the appellant, Dr. Abhishek Manu Singhvi, learned senior counsel for the respondent number 2, and Sri V.M. Kanan for respondent number 1. Submission on behalf of the appellant. The learned counsel for the appellant inter alia submitted. There is no dispute that the appellant had submitted its claim. Neither RP, neither respondent, nor anybody has challenged that the appellant has not filed any claim. It is on record that they have filed the claim. Now come to next. The meeting of the COC were not notified to the appellant. No notice was given to the Noida Authority, Greater Noida Authority. At the time of approving the resolution plan, the adjudicating authority failed to consider whether the plan had been made provisions commensurate to the appellant's claim, so and so and so. Now come to D. The finding that there had been a delay on the part of appellant in pursuing the remedies is misconceived, particularly when it was established on record the IA was filed, so and so and so. So he is pleading that there is a delay in filing the IA or in challenging the resolution plan. When the suspension of the period of limitation for any suits appellant application proceeding imposed between 15th, so there was a lockdown period, so lockdown period was excluded from the limitation period. So this appellant filed this application before AA within the limitation period as per the Honorable Supreme Court time given after COVID period. Now submission on behalf of the respondent. Now come to main, we will discuss the main paras from 35 onwards. However, what is important is that neither NCLT nor NCLAT rejected the assertion of the appellant that on 30th January 2020, in response to the public announcement, the appellant had submitted with proof a claim of 43.40 crores before the RP, being the amount payable to it by the CD towards unpaid premium, including interest payable thereon, for the lease allotment of land owned by the appellant. 36. According to the appellant, that is the Greater Noida, the resolution plan fails to take into account the following. Number 1, the appellant had submitted its claim with proof of so-and-so. The appellant had a statutory charges over the asset. Third, the entire land over which the project has been conceived is owned by the appellant. Fourth, D. A notice to cancel the lease for non-payment of dues had already been served on the CD. Fifth, with approval of the appellant, the plan was not feasible. Further, according to the appellant, the plan did not confer to the conditions referred in subsection 2 of section 30 of the IBC. Read with regulation 37 and 38 of the CRP regulation. And that the entire process of preparing the resolution plan and approving the same had been ex parte, thereby seriously prejudicing the interest of the appellant. It is the case of the appellant that neither NCLT nor NCLAT accorded the accorded due consideration to the above aspects while rejecting the application oblique appeal of the appellant.
Ajay, one question I have here regarding the constitution of the COC.
Yeah.
COC is purely home buyers in this case, or the
Yes,
bank?
yes, 100% home buyers.
Okay.
See, all these observation and these averments are very important to know the RP, to know it is very important for the RP, so that RP should be very vigilant while dealing with the claims, particularly this statutory authority. Per contra, on the above, on behalf of the respondent, it was urged that the appellant had pressed its cases only on the ground that it was a financial creditor. Once this, so this is not that much important, because the Supreme Court has not dealt with this, whether the appellant is a financial creditor or operational creditor, because appellant had right to attend the COC meeting by virtue of the quantum of the claim, because its claim was more than 10%. So Supreme Court has not dealt with the status of the appellant, whether he is the OC or FC. At this stage, we may put on record that the appellant had set up its claim as a financial creditor. However, the appellant was found to be an operational creditor, though a challenge to this finding has been led. But during the course of argument, the learned counsel for the appellant failed to demonstrate as to how could the appellant be considered as financial creditor. In view thereof, the taking notice decision of the Anand Sonbhadra. So they have relied upon the judgment of the Anand Sonbhadra. Upon consideration of the rival submission, following issues arises for our consideration in this appeal, whether in exercise of the power under subsection 5 of section 60 of 60, the adjudicating authority, that is NCLT, can recall an order of approval passed under subsection 1 of section 31 of the IBC, whether the application for recall of the order was barred by the time, whether the judicial plan put forth by the judicial applicant did not meet the requirement of section 30 subsection 2 of the IBC, read with regulation 37-38 of CRP regulation, as to what relief, if any, the appellant is entitled. Recall application here. Now, Supreme Court has dealt with the power of the NCLT with respect to recall of the application. Section 60 of the IBC specifies that the adjudicating authority in relation to insolvency resolution process and liquidation for corporate person, including corporate debtor and personal guarantor thereof, shall be NCLT, having territorial jurisdiction over the place where the registered office of the CD is located. Section 60 subsection 5 provides that notwithstanding anything to the contrary contained in any other law for the timing in force, the NCLT shall have jurisdiction to entertain or dispose of A, any application or proceeding by or against the corporate debtor or corporate person. B, any claim made by or against the CD or corporate person, including claim by or against any of its subsidiaries situated in India, and any question of priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceeding of the CD under IBC. So this is the enough power vested with the NCLT to deal with any issues with respect to the CIRP or liquidation process under section 60 subsection 5. Now NCLT has been constituted under section 408 of this Companies Act, which the Companies Act 408 has been defined in this judgment also. You can read here. Now come to power. Now check the power under Rule 11 of the NCLT Rules 2016, framed under section 469 of the Companies Act, which is in pari materia with section 151 of the CPC. See, sections 11, Rule 11 of NCLT and section 151 of Code of Civil Procedure both are equivalent. Preserve the inherent power of the NCLT in the following terms. Nothing in this rule shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such orders as may be necessary for meeting the end of justice or to prevent abuse of the process of the tribunal. So, meeting the end of the justice, NCLT can exercise its power under Rule 11. In Manohar Lal Chopra versus Rai Bahadur Rao Raja Seth Hiralal, a 4 judges bench of Honorable Supreme Court, while interpreting Section 151 of the CPC, observed that the section itself says that nothing in this court shall be deemed to limit or otherwise affect the inherent power of the court to make order necessary for the ends of the justice. In the face of such a clear statement, it is not possible to hold that the provisions of the code control the inherent power by limiting it or otherwise affecting it. The inherent power has been conferred upon the court. It is a power inherent in the court by virtue of its duty to do justice between the parties before it. In the similar observation was also given. The Supreme Court also relies upon the judgment of Greenlay Banks. Now come to in State Bank, State of Punjab versus Davinder Pal Singh. Same observation. Next judgment, New India Assurance. So there are a number of judgments they have relied. The law which emerges from the decision above. Now 48. The law which emerges from the decision above is that a tribunal or a court is invested with such ancillary or incidental powers as may be necessary to discharge its function effectively for the purpose of doing justice between the parties, and in absence of statutory prohibition in an appropriate case, it can recall its order in exercise of such ancillary and incidental powers. Similar judgment was also given in the Union Bank of India versus Dinkar T. Venkat Subramaniam. It was held that the power of recall of judgment can be exercised when any procedural error is committed. This is very important. If there is a procedural error, then NCLT can exercise its inherent power in delivering the earlier judgment. For example, necessary party has not been served or necessary party was not before the tribunal when judgment was delivered adverse to a party. It was observed that there may be other grounds for recall of a judgment, once one of them being where fraud is played on the court in obtaining a judgment. This decision of enclate was upheld by two-judge bench of this court. In the light of the above discussion, what emerges is a court or a tribunal, in absence of any provisions of contrary, has inherent power to recall an order to secure the end of the justice and to prevent abuse of the process of the court. Neither the IBC nor regulation framed thereunder in any way prohibits exercise of such inherent power. See, if you find any problem in CRP liquidation on any type of process, the simple way to approach AA under section 60 subsection 5, read with rule 11. So neither IBC nor regulation framed thereunder in any way prohibits. Now come to 51. In the case on hand, the recall application was filed by claiming that appellant was not informed about the COC meeting. The proceeding up to the stage of approval of the resolution plan by the AA were ex parte. Third, the RP misrepresented that the appellant had submitted no claim, when otherwise a claim was submitted of an amount higher than what shown outstanding towards the appellant. And there was a gross mistake on the part of the AA adjudicating authority in approving the resolution plan which did not fulfill the conditions laid down under section 30 subsection 2 of the IBC. So adjudicating authority has done very gross mistake while passing this resolution plan. Now 52. In our views, the grounds taken qualify as valid grounds on which a recall of the order of approval dated 4/8/2020 could be sought We thus hold that the recall application was maintainable, notwithstanding that an appeal lays before the enclave against the order of approval passed by the adjudicating authority. So here the Supreme Court hold that the NCLT was having power to recall this order, but NCLT did not exercise such power. Recall application was not barred by time. I have already explained initially that the time during the lockdown period, the time of lockdown period was excluded while counting the limitation period. So appellant has filed this application before AA during the limitation period. That is the grace time given by the Honorable Supreme Court. So now come to last para. In our view, the resolution plan did not meet the requirement of section 30 subsection 2 of the IBC, read with regulation 3738 of CRP regulation. This resolution plan disclose. Now, this is the judgment, the final verdict of this Honorable Supreme Court. The resolution plan disclosed that the appellant did not submit its claim when the unrebutted case of the appellant had been that it had submitted its claim with proof on 30th January for a sum of rupees 43.40 crores. No doubt, the record indicates that the appellant was advised to submit its claim in Form B, mint for operation creditor, in place of Form C, mint for financial creditor, mint of financial. But assuming the appellant did not heed the advice, once the claim was submitted with proof, it could not have been overlooked merely because it was in different form. So this is very important judgment of Honorable Supreme Court that the form doesn't matter. If RP or IRP received any claim, IRP or RP duty bound to admit its claim or record in the claim chart, whether form is incorrect or correct. It is not mandatory. The form A, B, C is not mandatory. If RP or IRP has received the claim along with supporting document, it has to admit in this and place in the record. Now come to, so you can take this defense while if anybody raise this question about the form, whether COC or IBBI, then you can refer this judgment. The form is not mandatory. But assuming the appellant did not heed the advice once the claim was submitted with proof, it could not have been overlooked merely because it was a different form. As already discussed above, in our view, the form in which a claim is to be submitted is directory. So this is very important line. Now, what is necessary is that the claim must have support from proof. So support must be there, even if it is on plain sheet, plain paper, email. If support is there, that is enough. Then IRP or RP is duty bound to admit the claim. Here the resolution plan fails not only in acknowledging the claim made, but also in mentioning the correct figure of the amount due and payable. According to resolution plan, the amount outstanding was rupees 13.47 crores. See, in resolution plan, in the resolution plan, the amount outstanding was shown as 13.47 crore. From where this figure came, nobody knows. The claim amount was 43.4 crores, whereas it has been shown by the RP, or I think it's RP, that it is a 13.47 crores claim. Whereas according to the appellant, the amount dues and payable, dues and for which the claim was made was rupees 43.4. The omission or error, as the case may be, in our view, materially affected the resolution plan, as it was a vital information on which there ought to have been application of mind. Withholding the information adversely affected the interest of the appellant because, firstly, it affected its right of being served notice of the meeting of the COC available under section 24 subsection 3 of the IBC to an operation creditor with aggregate dues of not less than 10% of the debt. And secondly, in the proposed resolution plan, outlay for the appellant got reduced, being a percentage of dues payable. In our view, for the regions above, this resolution plan stood vitiated. However, neither NCLT nor NCLATE addressed itself on the aforesaid aspect, which render their orders vulnerable and amenable to judicial review. Now, B. The resolution plan did not specifically place the appellant in the category of secured creditor, even though by virtue of Section 13A of the 1976 Act, that is Noida Authority Act, in respect of the amount payable to it, charge was created on the assets of the CD. As per Regulation 37 of the CRP, a resolution plan must provide for the measures as may be necessary for insolvency resolution of the CD for maximization of value of its assets, including but not limited to satisfaction or modification of any security interest. Further, as per explanation, the distribution under clause B of subsection 2 of section 30 must be fair and equitable to each class of creditor. Non-placement of the appellant in class of secured creditor did affect its interest. However, neither NCLT nor NCLATE noticed this anomaly in the plan, which vitiated their order. C. Under Regulation 38, subregulation 3 of CRP, a resolution plan must inter alia demonstrate that it is feasible and viable. B. It has provisions for approval required and the timeline for the same. So, the mandatory condition of the resolution plan that it is feasible and viable. But in the given case, the resolution plan was neither feasible nor viable because claim of the Noida Authority was not added. And the land and the owner of the land was Noida Authority because they have not paid, the CD did not pay the dues amount, premium amount. So Noida Authority's claim was not satisfied. So the plan itself is not feasible and viable. Now, in the instant case, the plan conceived utilization of land owned by the appellant. Ordinarily, feasibility and viability of the plan are economic decision best left to the commercial wisdom of the COC. However, where the plan envisages use of land not owned by the CD but by a third party, such as the appellant, which is a statutory body bound by its own rules and regulation having statutory flavor, there has to be closer examination of the plan's feasibility. Here on the part of the CD, there were default in payment of installment, which allegedly resulted in raising of demand and issuance of pre-cancellation notice. In these circumstances, whether this resolution plan envisages necessary approval of the statutory authority is an important aspect on which feasibility of the plan depends. Unfortunately, the order of the approval does not envisage such approvals, but neither NCLT nor NCLATE dealt with those aspects. Relief. Now last para. As we have found that neither NCLT nor NCLATE, while deciding the application appeal of the appellant, took note of the fact that appellant had not. Sorry, मैं आपको 5 मिनट में कॉल करता हूँ. The appellant had not been served upon the notice of the COC meeting. The entire proceeding up to the stage of approval of the resolution plan were ex parte to the appellant. The appellant had submitted its claim and was secured creditor by operation of law, yet the resolution plan projected the appellant as one who did not submit its claim. D. The resolution plan did not meet the all parameters laid down under section 30 subsection 2 of the IBC and regulation. We are of the considered view that the appeal of the appellant are entitled to be allowed and are accordingly allowed. The impugned order dated 24th November 2022 is set aside. The order dated 4th August 2020 passed by the NCLT approving the resolution plan is set aside. The resolution plan shall be sent back to the COC for resubmission after satisfying the parameters set out by the court as exposited above. There shall be no order as to cost. CRP was commenced May 2019. May 2019, the CRP commencement date was 30th May. Today is in February, the Supreme Court dismissed this resolution plan. So 5 years have been wasted of home buyers, of everybody, all stakeholders, only because of one mistake of RP. So this is so I thought this judgment is very important, that we should very careful about the claim, particularly when the statutory authority is there, particularly when the stake is very high. We should definitely, and even if suppose Noida authority has filed his claim and he has not attended, and if RP would have issued notice of COC and Noida authority has not attended the meeting, then situation would have been different. But RP has not issued any notice. RP has not admitted any claim of the Noida authority. So this is a gross negligence, gross ignorance on the part of the RP. There are 600 home buyers in this case. JNC Construction. The corporate debtor's name is JNC Construction, about 600 home buyers. And now, after 5 years, they have invested their lifetime savings. They have invested their time, money, everything. Any question on this judgment? I invite question on this judgment.
Ajay ji, this
Hello?
was a home buyer's case, so I'm sure there must have been an AR also. But nowhere the role of the AR has been studied, or his responsibilities, whether he, utilized that, or he too was ignorant or was careful. Because the feasibility viability was mostly the AR's work to
Yes.
be done here.
See, AR of home buyer, AR of not Noida authority, number one. The claim amount was not in the list. Claim amount was not on the radar of the RP. So AR was not supposed to interfere in the RP's work. AR is only supposed to convey the message, convey the voting right, voting percentage of this class of creditors to the RP. So AR role is very limited.
No, that's correct, sir. But when it comes to feasibility viability check, I mean, this has been there in the regulations earlier also, that it was the job of the COC, and the COC here is AR.
Yes, you are right. Here COC is the AR, but AR, see, AR cannot go beyond the records. If record says, see, if input is wrong, then output will also be wrong. The input shows that there is no claim of the Noida authority. So I think it was, so AR or COC must have thought that it is good for them that claim is very less. So our demand money from the CD will also be less, because their cost of the flat will also increase. Suppose if this Noida authority claim was in place, suppose, then cost of the flats would also have been increased. So I think they have thought it might be in their mind that let it go. That's it.
बुक्स ऑफ अकाउंट्स में 13 करोड़ की फी लगती है, जो आप बता रहे हैं।
Books of accounts may see in the judgment it is not mentioned that from where this figure has been arrived 13 crores, but somewhere it is written that 13 crores dues are there. This might be in books of accounts, I agree. Or
So then RP should have considered this amount at least in the list of claims.
IM says that Noida authority claim is 0.
But how can he ignore the claim of these are
Now-
13 crores as per books of accounts? So,
Now it's RP.
or he, because since it is, the whole project depends on the, ownership of the land. And the Greater Noida Authority is the
See,
ownership of the land.
in this
So he must have
judgment,
intimated to Greater Noida Authority that you have not filed your claim. And as per books of account, our figure is coming to be 13 crores.
see the
If you have any
prima
claim,
facie. Ajay ji, I got your point. The prima facie mistake is that the Noida Authority has filed its claim 43 crores, and RP has not mentioned anywhere in their IM, in their record, in their that the Noida Authority has filed claim for this much amount.
the claim was filed before issue of IM or after issue of IM?
No, it was filed much before IM, much before issuance of IM, because this claim was filed after 6 months. The CRP was initiated in May. Thereafter, some May 2019. Thereafter, some the stay period was also there, because I am aware about this JNC construction CRP process. And thereafter, IRP changed, then RP appointed. The RP received this claim in January 2020 after 6-7 months of commencement of CRP. So that till that no IM was in place. Even if
My point is,
IM could have been modified.
yeah. But my point is that even if there was no mention in the IM,
Yes.
there should have been a company balance sheet, audited balance sheet of the company, PD, where there should have been written these table figures of the Greater Noida Authority.
I think this 13 crores figure might have been drawn from the balance sheet.
So it
Because
shouldn't have been ignored.
judgment is not judgment is silent about the source of these 13 crores.
Okay, fine.
Okay. Now I will discuss another important aspects, another important topic, that is an RRA, not readily realizable assets. Most of the liquidation process stuck due to an RRA. Liquidation time given is 12 months, 1 year, but it process goes beyond 1 year, 2 years, 3 years.
यार ये इंश्योरेंस की हमें क्यों आती रहती है जो उसकी जो राजमणिकम सारी मेल में कॉपी हमें मार्क करते हैं
See, an IP plays, most of the IP plays 3 roles in one assignment. One, as an IRP after 30 days or 1 month. Second role come as a RP, and third role come as a liquidator. First role, there is a time limit, and after certain time, the position gets changed. Even in RP also, there is a time limit, and maximum time limit is also there, 330 days or 270 days. The CRP gets closed and corporate debtor, either resolution plan gets approved or goes into liquidation. But in liquidation, there is no time limit. Law says 1 year, but practically it dragged 4 years, 5 years. I have faced such a situation. My client, my client has faced such a situation. I will share this thing. So the reason of this thing, that NRRA, the most of the cases drag due to NRRA, not readily realizable assets, due to dispute in this property of the CD, land, building, machinery, plant, etc., or some types of PFU transaction. Now come to section 30, regulation 37A. Just a moment. Change your made. Now we should know, all IPs must know why this NRRA introduced and why this regulation 37A introduced in the IBC. It starts from discussion paper of IBBI. 20th August 2020. Assignment of NRRA, not readily realizable assets, where executive authority pass an order for liquidation of the CD, the power of the board of directors, key manager vested with the liquidator. Objective of the code is are realized only if the liquidation process closes in a time-bound manner. The liquidator moves on and the stakeholder recycle the asset stuck in the CD. Dissolution of the CD, while there is a possibility of recover some value of which is lying in NRRA, is against the interest of the stakeholders. On the other hand, if the dissolution is kept pending for want of realization of such assets, the liquidation process cost gets accumulated on continuous basis, while the value of the assets keep on depreciating with time. Presence of substantial NRRA in liquidation state creates a situation of stalemate, as realizable amount remains as best as guesstimate. Now come to BLRC report. The Bankruptcy Law Reform Committee, which conceptualized the code, considered the problem in its report. So what is the logic behind all these things? Before introducing the BLRC, discuss all these aspects in details. At this stage, there are possible recoveries of the assets of the entity in future. These are most likely to come from lawsuit to recover from the identified vulnerable transaction and cases of fraudulent action carried out by the directors of the erstwhile entity. However, these are highly uncertain. The trade-off is to keep this case open and accrues cost of the liquidation from liquidator fees on one hand, and on the other to close the case, dissolve the entity, but retain the liquidator trust, so that whatever recoveries are made can be deposited into the trust net of the liquidator cost of managing these lawsuits. Now come to liquidator required to take action recover. I will only discuss the one. See, if any assets stuck in litigation, then value of the asset get deteriorated. And the purpose of the liquidator, the objective of the CRP or liquidation is to maximize the value of the asset. So this is just opposite to the objective of the liquidation process. So this provision was introduced by the IBBI to expedite the liquidation process. It is worth to consider the assignment for what amount. Now come to option 1, option of assignment. So NRRA can be assigned. It is worth to considering the assignment of NRRA for whatever amount the market is willing to pay and distribute the same among stakeholders and close the liquidation process. To benefit the stakeholders, particularly creditors, when the liquidation state is insufficient to pay the debts, the liquidator can be provided with the right to assign certain statutory rights of action, such as avoidance, transaction action, contingent claims, etc., to the third parties, subject to certain safeguards. Looking at the best interest of this state as a whole, the liquidator may go forward to assign these assets to realize some value out of them and expedite to complete the process within the prescribed timelines under the code, under regulation, to the best possible extent. Option 1, absolute assignment. Under this option, the assignment of NRA will be absolute, and the assignee or party whom the assignment assets are assigned by the liquidator assigner would have right over the assets and any action related thereto. The assignment would include the transfer of all the legal rights, remedies, and power to bring the action to an end. For example, by settlement without interference of the assigner. So absolute power given to the assignee to realize the assets by whatever means. Now, assignment with recompense facilities. Assignment with the recompense facility with will allow the liquidator to assign the assets with an initial price. Any subsequent net discovery, that is value realized less cost incurred in the recovery process of the value over and above the initial price, would be shared between the assignee and assigner as per the terms of engagement entered into enforce the assignment. So here absolute assignment and second is the conditional assignment. First the initial payment and second after realization of certain values. So here the liquidator can fix the percentage of sharing. Now check and balance of 29A. See, while selecting the bidder under NRRA, you will invite the bid for NRRA, then you will have to select the bidder. Now you have to also test the bidder whether they are eligible for to acquire the NRRA or not. So whether they pass the test of the section 29 of the code. Section 29A of the code keeps out a person who is willful defaulter, undischarged insolvent, has an account classified as NPA for a defined period, etc., and therefore is likely to be risk to successful resolution of the insolvency of a company. The ineligible person under section 29A may have vested interest in buying these contentions assets during the. So here the person who wish to acquire, a person who wishes to acquire this NRRA must pass the test of section 29A. You know everybody this section 29A, the eligibility criteria for the bidder in resolution plan also, in NRRA also. Now consultation with stakeholder committee. Now second stage is consultation with stakeholder committee. The liquidator may also be required to have deliberation on the assignment of the NRRA with the SEC, who may have access to the relevant records and seek the following information as may be required for effective assignment. Whether there is a valid cause of action. So liquidator has to apprise the SEC about the action relating to NRRA, why assignment of NRRA is necessary. So this is required to be, the liquidator needs to apprise the SEC. Cause of action, the time value, time, recovery time, market status, etc. Now come to principle of. So after considering all aspects, other countries is also having similar kind of arrangement. Hong Kong, Singapore, or now position in India. In India, the law does not prohibit the assignment of cause of action. See, cause of action can be assigned. As per the Honorable Supreme Court judgment, the rigid British principle of champerty and maintenance are not applicable in India per se. The Privy Council in so-and-so case for the first time permitted third-party litigation funding on the ground of promoting access to justice in India and noted that agreement of this kind ought to be carefully watched and when found to be extortionate and unconscionable so as to inequitable against the party or to be made not with bona fide object of assisting or claim believed to be just and of obtaining a reasonable recompense, therefore, but for improper object, as for the purpose of gambling in litigation or injuring or of injuring or oppressing others by abetting and encouraging unrighteous suits so as to contrary to the public policy, effect ought not to be given to them. Now come to TP Act. See, judgment, all the judgment derived from the TP Act. The TP Act is very old. Transfer of Property Act 1882. Section 132 of the TP Act provides that the transferee, that is the assignee of an actionable claim, has to take its subject to all liabilities and equities to which the transferor was subject in respect in respect thereof at the date of transfer. So this assignee, assigner, all this comes through TP Act under section 132. So actionable claim can be transferred, can be assigned. This was also held by the Honorable Supreme Court in ICICI Bank matter. Now I will come to practical, that is the just so NR 37. Actually, the initially when the IBBI introduced this regulation, the regulation was marked as 38A, whereas after this during notification, the number has been changed to 37A. What is NRRA? Where the liquidation estate has any financial interest, including any rights to sue, that is conferred on the liquidator that is not readily or advantageously realizable, the liquidator may assign such interest under this regulation. Explanation: for the purpose of this sub-regulation, beneficial interest means and includes sundry debts, refund from the government. I think I will read directly from the judgment only. I am just closing this thing. Come to it is my practical experience that some tribunal is allowing NRRA, some tribunal is not allowing. So I am just coming to this new order that is passed by the NCLT Court 2, 27 February. I argued this matter because this IA was pending since 2020, January 2020. So 4 years old IA. Just see, the present application has been preferred by so-and-so, that is the assigner. Why assigner has moved this application? Because there was a stay by the NCLT in against the liquidator for not to assign any NRRA. So in this situation, the assigner has filed this application, to whom the liquidator could assign NRRA, which formed the subject matter of CA company application. Earlier, now it is IA, earlier it was CA. So company application 158/2020, January 2020. This application was filed in January 2020. So 4 years, about January. After 4 years, see, this order has been passed on 27 February 2024. This IA or CA was pending for 4 years. The salient plea exposed by the appellant is that since the trademark of Ujala has been assigned to appellant, it is entitled to be substituted as applicant in CA number so to pursue the application filed for questioning the undervalued transaction. Mr. Ajay Kumar, from the counsel appearing for the liquidator, supported the application and argued in vehemence that once the regulation 37 of the IBBI liquidation process permits the assignment of the NRRA, there should be no bar in allowing the substitution of applicant before us as applicant in CA number so-and-so to buttress the plea so-and-so. So I had argued before this tribunal that there should not be any impediment when 37A is after enactment of this 37A, after this introduction of regulation 37A, it is clear-cut given that any type of NRRA can be assigned, number one. Number two, the assignee will be step into the shoes of assigner. So I have taken two stands. Now come to main part of the order. Just I have also apprised the tribunal about the bankruptcy law report committee and thereafter completion of liquidated. See, the regulation 44, completion of liquidation. The liquidator shall liquidate the corporate debtor within a period of 1 year from the liquidation commencement date, notwithstanding pendency of any applicable application for avoidance of transactions so and so and so and so. Now, if the liquidator fails to liquidate the CD within 1 year, he shall make an application to AA to continue such liquidation along with the report explaining why this liquidation has not been completed and specifying the additional time that shall be required for liquidation. The purpose of Regulation 37 is to enable the liquidator to achieve the objective of Regulation 44. So 37A was introduced to achieve the purpose of 44, that is the time-bound process. The liquidation process must be finished within the time bound, that is 1 year. Now come to 44A. This is very important. Everybody must know this thing. The liquidator shall and treatment of avoidant trust. The liquidator shall, on the advice of the consultation committee, provide in the application along with the final report filed under Regulation 45 for the manner in which proceedings in respect of avoidant transaction, if any, under chapter so and so, or fraudulent or wrongful trading under chapter 6 of part 2 of the code will be pursued after the dissolution or closure of the liquidation process, and the manner in which the proceeds, if any, from such proceedings shall be distributed. From the above mentioned, aforementioned, it is clear that the avoidance application can be pursued even after the dissolution of the corporator. So my dissolution application was also pending since April 2021. So I argued that avoidance transaction can be pursued by the assignee. Let dissolution application be decided first. We may not be oblivious of the fact that after commencement of CRP, so the manager now come to when the assets of the third party considered. When the assets are assigned to third party for consideration, the assignee would have his remedy to recover the same in accordance with the law applicable to him, and it may not be permitted to step into the shoes of IRP. See, bench was not inclined to entertain this application because before this order, before this judgment, bench has dismissed the similar application and not allowed to assign the NRRA. The stand taken by the bench that you can assign the NRRA, but the assignee cannot step into the shoes of IP, RP or liquidator. The bench said only IRP, RP or liquidator can pursue the application under section 43 PUFE transaction in nutshell, preferential, undervalued, extortionate and fraudulent, not other person. So I am not allowing. That's why this was very difficult, that the same bench has rejected the earlier application. So I apprised the bench that no, the NRRA, this assignee has also right to pursue this application before this bench. Why? Because of section 63. Section 63 prohibits any civil court in interfering any proceeding relating to CRP or liquidation. Once the CRP or liquidation process ceased with the NCLT, civil court shall not interfere. So in view of section 63, assignee can pursue the case before NCLT only. Now again come to okay, here in order also it is mentioned. When the assets are third party, civil court not to have jurisdiction. No civil court or authority shall have jurisdiction to entertain any suit or proceeding in respect of any matter on which NCLT or enclave has jurisdiction under this code. Civil court not to have any jurisdiction. It is a misconception that the provisions contained in a particular statute can be relied upon only before the forum which created. Now come to the main part of this order, CA 15. CA 158, in the wake of the assignment of trademark of Ujala to the assignee ab initio, the council appearing for the liquidator seeks to withdraw the application in view of the prayer made by the. Here we have already executed the assignment deed. The liquidator has already executed the assignment deed and assignment was done by the liquidator. So in this order, the adjudicating authority NCLT passed that liquidator shall withdraw this application. Assignment is valid, but liquidator shall withdraw this application. Let assignee pursue this application. So whether assignee file press application before this forum or before civil court. The similar application also under IA 600 also the same order. Mumbai NCLT. Now come to Mumbai NCLT.
Ajay ji, one question here. What was the application about? I mean, after assignment, what was this application about? Because
Application
in
was.
law, I think there is no requirement of seeking any approval for assignment. Liquidator has the authority to do that.
Yes, you are right. You are right. See, liquidator has done all these things prior to filing this application. Liquidator had assigned this trademark, sorry, this IA, PFA transaction IA, and also received the part consideration. And part consideration was to be disbursed by the assignee in percentage after recovery of the from the NRRA. But what happened? NCLT, after assignment of this thing, NCLT passed a stay order that no liquidators shall not pursue anything with respect to NRRA until the further order. So due to this stay order, assignee moved this application that please allow this assignment in favor of the assignee. That's it. The prayer clause was to allow this assignment as a, or allow this or allow this assignment and allow this assignee to pursue this IA. This was the main this prayer.
Okay.
So here NCLT says liquidator shall withdraw this application. Liquidator has filed one application regarding PFA transaction and assignment is valid. He said the assignment is valid, but liquidator shall withdraw this application. Now assignee will pursue this application or shall pursue this as NRRA either before this forum or before other forum, which has not been recorded in the order. He has just simply says that, and recently he has passed another order which is contrary to this order.
No, sir, I could not understand. So the AA asked the liquidator to withdraw which application? What was the application? What was the prayer there?
PFA.
So PFA application he has to withdraw and the assignee will file again.
Yes.
But assignee does not have a right. I mean, it
Yes.
is the liquidator's or RP's right to do that.
Yes. That's why this day before yesterday was another order by the same bench. In that order, he has allowed the assignee to pursue this IA without withdrawing the PFA application. So this bench has contradicted its order day before yesterday. It's only. I am awaiting for this order. Somebody told me that the same bench has contradicted its previous order. That is
but the assignee is a third party. I mean, he does not have the information. So he is just a buyer in the process of certain, assets, which happen to be NRRA.
PFA transaction, yes.
Yeah.
So now he is in limbo, to be very honest, but liquidator has been absolved from this jugglery. He was waiting for 4 years. He had waited for 4 years to because this matter was pending since it has been pending since January 2020.
No, if that is going to be the fate of such applications, suppose if this becomes in general a rule, then where is the maximization of assets? Because no assignee will give good value when they realize that they have to again file an application.
But SCC has agreed for this thing.
Okay.
That the initial payment X amount, and thereafter whatever they have they will recover 50-50 will be done. 50-50 allocation will be done. 50% will be retained by the assignee. 50% will be distributed to COC member, SCC member.
Okay.
Now, Bombay NCLT is very clear. Come here. Now, just this is also order of 16 January 2024. I will come to the only operative part. Given that assets underlying the avoidance transaction application are the only assets pending realization. See, a liquidator has already sold all assets. In Ujala case also, liquidator had already sold all assets except this NR. In this case also, the given that the assets underlying the avoidance transaction application are the only assets pending realization, hence, in order to expedite the realization process and maximize the value of the liquidation estate, the liquidator intends to seek necessary direction from the bench to sell the assets underlying avoidance transaction application, hence the present application. Regulation 37A. Liquidator may assign transfers also, so you must have read all everything. Explanation is very important. For the purpose of sub-regulation, for the purpose of this sub-regulation, not readily realizable assets means any assets included in the liquidation state which could not be sold through available option and includes contingent or disputed assets and assets underlying proceedings for preferential, undervalued, extortionate, credit and fraudulent transaction referred to in section 43 to 51 and section 63 of the code. So explanation is very much clear that NRRA includes all assets including PUFA transaction. From a bare perusal of the above provisions, we find that liquidator subject to concurrence of SCC is vested with the power and authority to assign the assets considered to be not readily realizable assets. Further, Regulation 37 of the liquidation process regulation also contemplates distribution of the assets among the stakeholders. Accordingly, we have no hesitation to hold that the liquidator may proceed to consider assigning the avoidance application to third party in consultation with the stakeholder consultation committee. Insofar as prosecution of such pending application by such assignee is concerned, we are of the considered view that the application already filed by the person competent to do so can be prosecuted by the assignee subsequently. In view of the above, so is disposed of. So Bombay NCLT has given very clear-cut order as compared to Delhi NCLT. One thing more, that I have also read judgment of Anclate in the case of which is also very important. Just a minute. No. Sorry, it was not in this case, in different case. Now I will share. We have already discussed this second topic, liquidation regulation 30, to understand the concept of NRRA, BLRC, Supreme PP Act. Liquidation process can be, whether liquidation process can be stretched for unlimited period due to pendency of the, whether PUFA can be assigned, whether assignee can be step into the shoes of assigner. Yes, as per Bombay NCLT. Now Anclate judgment in the matter of Rahul Gupta versus Chandra Prakash. issues whether NCLT can take cognizance under Section 70 and pass the order for violation of non-compliance of order under Section 19(2) or Section 14 or Section whether NCLT has power or take the cognizance under Section 72, 70. Can anybody say? Any friend? Anjali ji, shall we take break for 5-10 minutes?
Sure.
So it's we will join at 3:35.
Okay, sir.
Thank you. Once again, good afternoon. Welcome, everybody. We are discussing whether NCLT can take cognizance under Section 70 and pass the order for violation of non-compliance of order passed under Section 19(2). Everybody, I think most of the IPs file this application, non-cooperation application, or application for violation of moratorium, or action under Section 66 regarding fraudulent transaction. In the matter of Rahul Gupta, Mrs. Divya Gupta, both are suspended directors. And Chandra Prakash is the RP, now he is the liquidator. This order was passed in October 2023. This appeal has arisen from the impugned order dated 7th June 2022 passed by the NCLT New Delhi Bench 3. In the instant appeal preferred by the suspended board of directors of James Batteries Private Limited against the order dated so and so. This is a very interesting matter. I think everybody is available. Am I audible?
Yes, sir.
Yes, sir. Yes.
You're audible.
Okay, thank you. See, we all IPs, we all used to file this 19(2) application, and we mention in the prayer clause to ask the suspended director to cooperate us, blah blah blah. But here in 19(2) application, they have prayed for imposing penalties, etc. Also. Now look at this judgment parts order part. They are allowing the application. See, NCLT allowed this application under Section 92 and imposed a cost of rupees 10 lakh each on the appellants. That is 2 directors, 10 lakh against both the directors under Section 70. What is Section 70? Criminal offense. I am just reading for your knowledge. Punishment for misconduct in the course of CIRP. On or after the insolvency commencement date, where an officer of the corporate debtor does not disclose the resolution professional all the details, properties, etc., does not deliver the resolution professional properties, etc., does not deliver the resolution professional all books of accounts, fail to inform their solution fails to inform their solution professional the information in the knowledge that the debts has been falsely provided by any person during the corporate insolvency resolution process. Fifth, prevent the production of any books or papers relating to the property or affairs of the CD. Sixth, accounts for any part of the property of the CD by fictitious losses or excess. Means not cooperating, not providing information, or manipulating the information, or some mischievous acts has been done by the suspended management. In that case, what is the remedy? In under Section 70, it says that he shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine, which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both, provided that nothing in this section shall render the person liable to the punishment under section so and so, provided he had no intent to do so in relation to the corporate affairs. So here the penalty is minimum 1 lakh, maximum 1 crores, or imprisonment for 3 years. In case of violation of section 19(2) or non-cooperation by the suspended management. I think most of the IPs are not aware about this thing. They just simply file 19(2) application and seek remedy that just direct the suspended director to assist the RP or provide the information, records, etc. So that's why I have taken this judgment. Now, so under it is the case of the appellant that adjudicating authority, while passing the impugned order, failed to appreciate the fact that section 70 of the code comes within part 2, chapter 7 of the code, which deals with the offences and penalties, and appropriate order, if any, under section 70 can only be passed by way of trial offences by a special court in terms of section 236 of the code. Appellant take a plea that AA cannot exercise such power. It can be exercised by the only special court under section, in terms of section 236. What is 236? Trial of offense by special court, notwithstanding anything in the code of civil criminal procedure. Offences under this code shall be tried by the special court established under chapter so and so of the Companies Act 2013. No court shall take cognizance of any offence punishable under this code act, save on the complaint made by the board. This is very important. I think everybody is listening. I am again repeating this subsection 2 of section 236. No court shall take cognizance of any offence punishable under this act, save on a complaint made by the board. Board means IBBI, or the central government, or any person authorized by the central government in this behalf. So complaint can be filed by the IBBI or central government, or person authorized by the IBBI or central government. And offense can be tried under it. It is a tribal offense and can be tried by the special court. Special court means a special court established under the Companies Act. If there is no special court, has actually in practical session, if you practically see, all court has has earmarked as a special court, like in Rohini court, in Tisjari, or in Gurgaon court. Some court has marked as a session court as a special court. Some court has marked a district magistrate as a special court, like that. So the respondent is Mr. Chandra Prakash, liquidator, erstwhile RP of Jain. Now come to the respondent alleged that the appellant were not cooperating with the respondent and they were not providing the document information in respect of the CD. That is the normal complaint of all IPs, all IRP RPs, that directors are not cooperating, directors are not informing, directors are not providing documents, etc., etc. The adjudicating authority on 25th November 2021 directed the appellant herein to ensure that the information document as listed in the email dated 24th so be provided to the respondent within 15 days from the date of order, and also directed the appellant to file compliance affidavit. The adjudicating authority wide order dated 7/6/2020 allowed IA, whereby the AA held that appellants failed to extend the cooperation to the respondent and imposed a fine of rupees 10 lakh on both the appellants. The adjudicating authority held as under. The conduct of the respondents clearly shows that they no intention, I think that's typing error, they have no intention to provide their assistance to the liquidator in the liquidation process which falls within the purview of section 70 of the IBC. Hence, we are inclined to take penal action against the respondent and hereby punish the respondents number 1 and 2 with fine of rupees 10 lakh on each of the said respondents, and same shall be deposited in the credit of the pay and account officer, Ministry of Corporate Affairs, New Delhi, in 2 weeks from the date of this order. It is further directed to the suspended board of directors to provide all the information as sought by the applicant in paragraph 8 within 1 month. Now come to the appellant submitted the appeal we allowed. Para number 12. It is further the case of the appellant that the adjudicating authority erred in exercising the power under section 236 of the code, which has only been vested with the special code under, and the AA erred in considering the true scope, effect, purported of section 70 of section 236 of the code, and failed to consider that section 236 of the code stipulates that no court shall take cognizance of any offense punishable. I have already read these provisions. That no court shall take any cognizance of the offense unless and until it has been filed by the IBBI or central government or officer authorized by them. So here NCLT has misconstrued the provisions of section 236 and exercised the power under section 70. The appellant pleaded that the impugn orders entering in Vivek Prakash case also in Mahindra Union of India versus Maharashtra Development Corporation. In this case also the NCLT has, company appeal. NCLT has held that order for punishment can be passed only by way of trial of offense by special court in terms of section 236 of the code. Now the respondent retreated the appellant where trial of offense by the special code. I have already read these provisions. The offense can be tried by the special code only established under the Companies Act 2013 upon the complaint of the IBBI or central government. Now read Rule 11 of the NCLT. Yeah, I have already read this Rule 11 in previous judgment that NCLT has inherent power for meeting the end of the justice. Now come to in this case of Vikram Puri, the similar order was passed. In Vivek Prakash also same order that the only special court can entertain the complaint under section 70. Complaint under section 236 and prosecution under section 70. However, with regard to any offense, including the offense under the Indian Penal Code, if any complaint is filed by the registered professional before the police station, that is separate issues and has no concern with the offense under section 70, and the order impugned shall have no bearing on such proceeding by a police station, and they are independent proceeding which has to be considered and decided in accordance with the law. So in this order, this Vivek Prakash suspended actor versus Dinesh Kumar Gupta liquidator. Here NCLT says that if complaint has been filed with the police officer, then that complaint will be treated as a different complaint. It has nothing to do with the IBC complaint, 236 complaint. Now come to operative part of the judgment. After careful perusal of the above discussed six judgments of this appellate tribunal on earlier occasion, which are on the similar facts, we without any hesitation conclude that clearly the adjudicating authority erred in passing the impugned order, overlooking the law of the land, that is the code, and also ignoring the precedent cases settled by this appellate tribunal as discussed in preceding paragraphs. Based on the above detailed analysis, we are unable to sustain the impugned order. In fine, the appeal succeed and impugned order is set aside and remanded back to the NCLT bench 3 to have fresh look of the case and decide in accordance with the law and pass the suitable order. The appellant and respondent are directed to appear before NCLT. So in this case, I asked one question to you that if first I ask you, have you filed any complaint to IBBI that directors are not cooperating or directors are not providing documents, so take appropriate action? Has anybody filed before IBBI? Because 19.2 sometimes takes time. It gets delays due to multiple application, multiplicity of the proceeding before NCLT. In case of non-cooperation, you have two remedies. One is 19.2 application before AA. Another is complaint before IBBI under section 236. Consequently, upon your complaint, IBBI will file a complaint before a special court against the director. A special court shall issue summon. Thereafter, FIR will be registered. Thereafter, trial will take place. IRP will be also called for witness. RP liquidator IRP for witness, and thereafter punishment will be given to the director. This is the normal procedure before the special court. Now come to so it is clear that the adjudicating authority cannot pass any order under section 70. Now, resignation by the liquidator. I ask you whether liquidator tender his resignation during, whether liquidator can tender his resignation during his tenure, whether AA accept the resignation even if SCC does not accept the resignation. Can anybody say that whether liquidator can tender his resignation? Or if SCC...
Yes, sir. Yes, sir.
Okay.
Yes,
And
yes, he can continue.
he can tender resignation. And if SCC does not approve, then
I think we have to go to NCLT.
now I will come to the I have come across with this case where the liquidator, the SCC has not approved his resignation. This was the case of between Anil. This is the Earth Iconic. And the order delivered on 5th April in this month only. I argued the case on behalf of the liquidator. The application has been filed by for the replacement of the liquidator on account of resignation. Heard the counsel on behalf of the applicant. It was submitted that the present liquidator, who is Mr. So-and-so, Mr. Manchanda, has tendered his resignation on 16th January 2024 due to some health reasons, and the resignation was addressed to the stakeholders committee. And the same was placed before the SCC also in view of the facts that the liquidator does not want to continue this work. There is no point in keeping his here in order. It has not been mentioned that the SCC has not approved. In fact, I have gone through all this because I had argued this case. SCC had rejected this resignation by 70% voting. So I apprised this NCLT that even if SCC has rejected, the liquidator can take his final call, number one. Number two, NCLT has inherent power to replace this liquidator. And I also argued about the section 16 of the General Clause Act. Do you know General Clause Act 16? I'll share this General Clause Act also. And the same was placed before the liquidator. Yeah.
Sir, what was the reason for SCC not accepting the resignation?
Because the liquidation process was pending for more than 2 years, so they did not want that, because liquidator was aware about each and every aspect, and liquidator in this case liquidator was aware about all aspects, everything, and 2 years he has already spent. So they did not want that the new liquidator comes and he starts from the scratch. This is the main reason. So that's why they rejected their resignation. Therefore,
No,
from
but there is an inherent right for every person, sir, whether to continue.
no, inherent. No. Earlier, there was no provisions in the code or in the regulation that any IRP, RP or liquidator can resign from the assignment. Recently, this regulation 22A was introduced in the IP, Insolvency Professional Regulation 22A, in which it has been mentioned that liquidator, IRP or RP can quit this job with the approval of the SCC COC. Wherever.
But there were instances where the liquidator has resigned, and that with the resignation, SCC filed an IA before NCLT seeking for change in the liquidator, and those were allowed. There are instances.
Yes, you are normally it happens that the liquidator don't want to resign from the post. It is the SCC or COC replace the liquidator or RP. But here situation is different. That's why I have taken this case. The situation is different. The liquidator wanted to quit. So here the application was therefore from the panel of IP for a period of January so the IBB and the keeping in view the communication received in this regard from the registry, we hereby appoint Mr. Vaneet Bhatia so as a liquidator. In the present case, the appointment of the liquidator director to file written consent so. So in nutshell, it has been allowed. The application has been allowed. Now I'll come to order of Mumbai NCLT liquidator and plate. Here, the appellant is CAV Venkatas, that is liquidator is the appellant here. Now I'm coming to just law points. Just control and I am coming to only law point. Being an insolvency professional, we must know. In Supreme Court, this matter, in the case of state of Tamil Nadu and so, SCC so, the question is whether the expression appointment used in this termination, compulsory retirement, used in this government order dated so will include termination of service or compulsory retirement from the service also. Here I am discussing on the other side, whether NCLT can terminate or can appoint another liquidator. It is a fundamental principle of interpretation that unless a contrary intention appears from the context, a power to appoint should include a power to terminate. The appointment including termination of the person appointed by his compulsorily retirement in accordance with the terms and conditions of his service. This fundamental principle underlines Section 16 of the General Clause Act. As I said, in other words, the power to terminate the appointment by compulsory retirement or otherwise is a necessary adjunct of this power of appointment and exercised and as an incident to or consequence of the power in the case of so and so. We may also in this connection recall the provisions of Section 16 of the General Clause Act. Whether or not the section in terms applies to the aforesaid standing order of the company which are certified under Section 5(3) of the Industrial Employment Standing Order Act 1946 may be a moot point, but the general doctrine underlying the section can well be made applicable to a case of the present nature, for it is now firmly established that the power to terminate service is a necessary adjunct of the power of appointment and in exercise of an incident to or consequence of that power. See Lekhras, this is citation. Now come to, so they have referred this clause, General Clause Act 16. So in our IBC also the NCLT has power to appoint liquidator. It has also power to terminate the services of the liquidator. The appellant tribunal also notes that in the recent judgment passed by the principal bench and Clate held that liquidator does not have any personal right to continue in the liquidation process, and the reasons which have been noted in the order are sufficient to exercise even the inherent powers by NCLT to replace the liquidator. It is not a fit case to interfere in the exercise of our appellate jurisdiction. This clearly establishes that no liquidator has any personal right to continue in the liquidation, or adjudicating authority can order replacement of the liquidator recording the sufficient reason as per law. So he has given the citation thereafter, also taking the base of clause 16, section 16 of the General Clause Act, and replace the liquidator. Now, whether commercial wisdom of the COC can be challenged? If yes, on which ground? Can anybody say? I put a question whether commercial wisdom of COC can be challenged. If yes, on which ground? Am I audible? Legality.
Yes, sir. Yes, sir.
Okay. On which ground? Okay, let's discuss. NCLT held that the commercial wisdom of the COC only to be challenged on the ground of material irregularity or fraud. Alokji has sent one message in chat box that on legality, that is true. Recently, the NCLT ordered that when the liquidation was ordered by the Committee of Creditor with 100% majority vote, which led to the commercial wisdom of the COC be converted into decision of the liquidation as per section 33 subsection 2 of the IBC, instead of calling for resolution claim. Recently, the NCLT ordered that when the liquidation was ordered by the COC with 100% majority vote, which led to the commercial wisdom of the COC being converted into a decision of liquidation as per section 33 subsection 2 of the IBC instead of calling for resolution claim. The commercial wisdom of the COC only can be challenged on the ground of material irregularity or fraud as per section 61 of the IBC, 61(4) of the IBC. What is 61 subsection 4? Appeal and appellate authority. Subsection 4. I am just coming straight forward to an appeal against a liquidation order passed under section 33 or subsection 4 of section 54L or subsection 4 of section 54N may be filed on the ground of material irregularity or fraud committed in relation to such liquidation order. So in case of material irregularity or fraud, the decision of the COC can be challenged. Otherwise not. Now next question, whether affidavit qua 29A given by the resolution applicant is suffice for RP to accept the resolution plan. When you invite resolution plan, resolution applicant file its affidavit undertaking that yes, I am compliant of 29A, I fulfill all conditions of 29A, whether that is sufficient for RP to go ahead with the resolution plan. Are you available physically also on Zoom? Ashish Giriyaji, I think your video is on or off. Ashish ji? हाँ, Murthy ji, please tell me. While you invite EOI or resolution plan, the resolution applicant file resolution plan or EOI along with the affidavit and undertaking that he is compliant of section 29A. Whether such affidavit or undertaking is sufficient for the RP to go ahead with the resolution plan. Unmute कर लीजिए, Murthy ji, please unmute yourself.
There are cases that 29A complaints, the responsibility lies with the RP, and in some cases with COC. So I think an affidavit won't suffice, sir. I think he has to take it into a form of a due diligence and then be satisfied himself that the 29A compliance is there with respect to that prospective resolution applicant or the resolution applicant.
Very true. Very true. I have collected all these 6 from different sources. The Mumbai NCLT, the RP filed an application for seeking of approval of resolution plan of Mr. Mahesh Mathai as AFC of the CD. The COC resolved to approve the said plan by majority of 91.86%. The Honorable Bench of NCLT Mumbai rejected the application and held that the resolution professional has the responsibility to conduct section 29A due diligence a prospective resolution applicant submitted an affidavit stating that he or she is eligible under Section 29A to submit resolution plan will not suffice. Further, a common theme across all decisions of the NCLT and the Supreme Court is an underlying notion that incumbent management and promoters of the corporate debtors should not allow to regain control of their company. We are of the view that Mr. Mahesh Mathai is not eligible to submit a resolution plan as he was a former promoter or director of the company and has contributed to the downfall of the company. Further, it appears from his shareholding patterns that he was always involved in the company. In fact, after his resignation and whilst the company was under financial distress, his shareholding went up from 4,36,757 equity share to 5,13,458 shares, equity shares in the year 2019-20. The said resolution plan cannot be allowed as it is in violation of rationale behind insertion of Section 29A, which was to protect the interest of creditors from persons who have contributed to the mismanagement and default committed by the CD. So this is the order passed by the NCLT that a person who has himself contributed this distress, who has dragged this company into distress position, cannot be a part of resolution applicant. And RP is supposed to do all due diligence under Section 29A. Whether check issued prior to commencement of CRP and encashed during CRP would be treated as preferential transaction? हाँ, मूर्ति जी, please. कि वत्सा कुमार जी.
Sir, in case the check has been issued in the normal course of activity, suppose maybe it is given to a supplier during the normal course of the business, running of the business, then it cannot be treated as a preferential transaction. Otherwise, it is a one-off transaction where the check has been given, then it will be treated as a preferential transaction.
What is your view, Vatsa ji?
Sir, I think as rightly pointed out, if it is the check has been issued prior to CARP and it is like, you know, in the normal course of business, then I think it should not come under the preferential transactions. Sir.
What suppose check has been issued prior to CRP, but it has been encashed after CRP?
That can be a technical issue, no, sir. That I don't think we should be dwell into it really. Prior to CRP, the normal course of business, suppose with the parties with whom we are regularly dealing for supplies of materials and all that, we are issuing a check, and the check gets presented, and then in between the CRP date has come in. So unless it is of suspicious nature, I think we need not look into it, sir.
The intent has
because
to
if the check has been issued to the related party, like for example, if it has been issued to some related party, yes, there is a suspicious nature to it. Otherwise, in the normal course of business with people whom regularly the transactions are happening, there is no suspicious nature of the transaction, then I think it need not be looked into, sir.
Very true. Thank you.
Yes, sir. Yes. Yes. Enlightened it crisp and clear.
Sir, one more thing, just it's pertaining to the earlier point of Section 29 compliance, sir.
Yeah.
Sir, I just wanted to know now from the IP, from apparently the case law you mentioned, from that it is obvious, it is coming out very clear that earlier that director was actually involved with the company. Okay, so that is a possibly the RP either knowingly or unknowingly has missed it. Okay, so that is a specific case, sir. But otherwise, in the normal course, like, you know, when apparently there is nothing, the RP feels ki okay, they are not related parties, there is no issue. Then what is the safeguard that the RP should take? Should we insist upon a proper report by an agency and then fall back on the report and then justify it on records? Is it that way mandatory for all the cases?
See, law is silent about this, but to protect ourselves, we must appoint some professional or we must do due diligence about the competency of the bidder, whether he is legally competent or not, he is eligible or not. We must do due diligence. We should, being RP or IRP, we can appoint professional now. Lots of agencies, they are doing due diligence of 29A. So why RP should involve himself? He cannot delegate his power. As per the regulation, as per the IBC code, RP is still responsible, but he can take assistance. He can take assistance of the professional, external professional for conducting due diligence in order to safeguard uh, the IP's position, safeguard the stakeholders also, safeguard the timeline also, because timeline we have to finish the, suppose you invited resolution plan and after receiving affidavit and everything, COC approved the resolution plan, and later on it reveals that the bidder was not eligible. Then entire process, entire efforts, entire timeline will be wasted.
So the same logic applies in liquidation also, sir. 29A. So
Yeah.
successful bidder, we have to satisfy
Yes.
ourselves. Possibly
Yes,
you are
yes.
saying ki, okay, rely on a report from a professional agency and then draw your own conclusions on it.
Yeah. Sure.
Okay, thank you.
Welcome, sir.
So dwelling on the same point, see, recently I've seen in one of the groups that the responsibility lies with the COC to some extent on the compliance of 29A. I don't remember the case law very well. I don't remember it, but it was, I read it in one of the groups that now that the responsibility is also with COC on 29A compliance. That's one thing I want to know from you. The second one is that the allied point or their 29A applicability compliance, is it a continuing one or as on the date of the filing of the resolution plan, submission of the resolution plan? These are the two things if you can just highlight us.
Can you repeat second one, please?
Sir, the compliance of the 29A, is it as on the date of the submission of the resolution plan or it's a continuing thing? Because these days, RPs take an undertaking again that if there is a time lag between the submission of the resolution plan and then finally getting it approved and before submitting it to NCLT. Just before submitting it to NCLT, suppose a successful bidder say, resolution applicant say, they take an affidavit again saying that they are still compliant with 29A. वो self declaration लेके उसका साथ file कर रहा है. This is the practice some RPs are following. First time initially check करने का time में they are using the professional services of legal houses to know whether they are compliant, 29A compliance is there, but subsequently when there is a time lag before filing of the application before NCLT, they are taking an affidavit and along with the affidavit they are filing it. Is it that the complaint should be
Here,
during
compliance should be continued. Their position should not be changed at the time of filing of resolution plan and before approval of resolution plan. His position should not be changed. He should not be declared as non-compliant or not eligible under section 29A. Number one. Number two, as you said, the COC is also duty bound to do due diligence. Yes, morally they should also do, but legally they are not liable. IBBI will not catch to COC, NCLT will not catch to COC. The person who is mainly responsible is only RP or IRP.
okay.
This is the order of Honorable NCLT Kolkata. This is the brief of the brief. In this case, the erstwhile management of the CD had issued a check in favor of the respondent dated January 2022, which was presented for encashment by the respondent on 17th February 2022. And the same was encashed on 18th to 22. After commencement of CRP, that is 12th January, the CRP was commenced, but check was encashed in February. The check was issued before commencement of CRP. 8th January was the check dated. The check dated is 8th January. CRP commenced on 12th January. Check encashed on 18th January. The RP is of the view that such encashment is preferential transaction and has been complete violation of section 14 of the IBC. An application was filed by the RP seeking to refund of check amount along with the interest thereof from the respondent. The Honorable Bench of NCLT Kolkata, while relying on the judgment of Apex Court in the case of K. Saraswati versus PSS Soma Sundaram Chetya, held that the payment of the check released subsequently relates to back to the receipt of the check, which in the instant case appears 8 January, and since the moratorium was declared on 12 January, this transaction is view of the ratio of the Ogale Glass Works does not violate the moratorium. So NCLT Kolkata relied upon the judgment of Honorable Supreme Court in K. Saraswati that if check has been issued before moratorium, then it doesn't violate. Simple. Therefore, in our considered opinion, this transaction cannot be termed as a preferential or violative of moratorium. Accordingly, IA was rejected. IA of the RP was rejected. Now we will also take some more cases. One more case I will take, and thereafter question answer session. If any you have any query, we can discuss. Sorry, still. Shifting of plant.
చెప్పండి చెప్పండి ఈవినింగ్ కలుద్దాం అంటే ఈవినింగ్ కలుద్దాము మీరు చెప్పండి ఎక్కడ కలుద్దాం
I have a query. I wish to ask you one question. Suppose CRP.
కలిస్తే 6 కలుద్దాం లేకపోతే 8 కలుద్దాం
Murthy ji. Okay, you are talking. Okay. I have a question. I just ask one question that
Okay.
suppose
So,
CRP, the last date of CRP is say 30th September of 2023, and COC passed the resolution for extension of CRP on 25th September, but RP filed an application for extension on 5th October.
sir, can you
Whether-
repeat, sir? We'll note down just.
COC approved the extension of CRP period before
Okay.
expiry date of the CRP. COC approved, passed the resolution for extension of CRP before expiry of the CRP period. Simple.
Okay.
And application has been filed after the expiry of CRP period. Whether application is sustainable or not.
Sir, condonation of delay ka sir sustainable hai sir. With the condonation of delay. Hello.
Yeah.
With condonation of delay, I think.
Okay, condonation of delay. Anybody else? Because I have faced this situation for my client, and the NCLT Mumbai rejected the application for extension on the ground that the RP has filed this application after the after the expiry of CRP period.
But there should be some reason why he had filed late.
Now come to the judgment part. And
There should be some reason.
I filed an appeal before the enclave.
So there should be a reason, no, sir?
This judgment is still relying upon. This is the case of Quantum Limited. Appellant, I represented the appellant. The appeal has been preferred by the corporate debtor through RP on so-and-so. By the impugned order, the AA has rejected the application for extension of time on the ground that there is no provisions to file such application after the expiry of 180 days. The relevant part of the portion on the application moved by the RP seeking extension of time for 90 days, another 90 days in which under section 12(2) of the IBC. When this bench has looked into the application, it has been noticed that this application has been filed on 30th November 2017 and on a resolution dated 24th November 2017 passed by the COC seeking extension of time. By the time this application was moved by the research professional, 180 days of CRP was complete by 25th 11 2017. On visiting the provisions of law, we have noticed that these applications shall be filed by the RP for extension of CRP period before completion of CRP period. But this application has been filed after the expiry of original period of 180 days of the CRP. If at all this application is allowed, it will become nothing but revival of CRP period that was completed by 25th November 2017. Since there is no provisions for revival of CRP period to provide another 90 days extension as mentioned under section 12(2) of the IBC, especially when earlier 180 days period is complete by the time application has been filed before AA, we strongly believe that it will become nothing but exercise of jurisdiction beyond the power conferred upon the bench. Under section 12, since it is a tribunal created by the court itself, this AA has to be governed by the provisions of this code. There can't be any doubt to say that extension can't be construed as revival. Revival can be after expiry of period, whereas extension has to be given before expiry of the original period. Here NCLT says that we can give the extension only before the expiry of the original period, cannot be given after expiry of the CRP period. Since speed and timelines are hallmark of this code and there being no provisions either for condonation or revival under any of the provisions of this code, we are of the view that AA is devoid of jurisdiction to revive the CRP period already completed by so-and-so, 25th November 20. By the time this application has come before this bench, therefore we don't find any merits in the application whereby this application is hereby dismissed. Now, enclate. Varsa Banerjee Lade, I was also, the Varsa was accompanied with me. This one applicant submit that 12(2) do not mandate that application for extension of time should be filed before completion of 180 days. See, if you read section 12(2), section 12, time limit for completion of insolvency. The resolution professional shall file an application to AA to extend the period of the CIRP beyond 180 days if instructed to do so by a resolution passed by a meeting of the COC by a vote of 66% of the voting shares. So it says that RP shall file an application with the approval of COC of 66% vote. That's it. It doesn't say, we argued before enclave that it doesn't say that it should be filed prior to completion of CRP period. So we took the benefit of this thing. Now, so Mr. Vinny Jagta advocate appeared for the on behalf
But why
of
is the delay
respondent
there?
and
Is it
endorsed.
an explainable delay or unexplainable delay?
I'm just coming to your point also. Just more. and endorse the submission made by the learned counsel for the appellant, Mr. Ajay advocate appeared on behalf of the Jain Financial Reconstruction, submit that there is no provisions to file an application for extension of time within 180 days, and submitted that for extension of time instruction was given by the COC to the revision profession by majority of vote of 75% within 180 days. Earlier it was 75%. Now it has been reduced to 66%. Section 12 prescribe the time limit for completion of insolvency resolution process, which I have already read these provisions. Now come to from subsection 2 of section 12. It is clear that resolution professional can file an application to AA for extension of the period of the CIRP only if instructed to do so by a resolution passed at a meeting of COC by a voting of so much percentage. The provisions does not stipulate that such application is to be filed before AA within 180 days. The same stand was taken by us. If within 180 days included the last day, that is 180th days, a resolution is passed by the COC by a majority vote of 75% of the voting shares, instructing the resolution professional to file an application for extension of period in such case in the interest of justice and to ensure that the resolution process is completed following all the procedure times should be allowed by the AA, who is empowered to extend such period up to 90 days beyond 180 days. In the present case, the AA has not hold that the subject matter of the case do not justify to extend the period. It has not been rejected on the ground that COC or resolution professional has not justified their performance during 180 days. In such circumstances, it was the duty on the part of the AA to extend the period to find out whether a suitable resolution plan is to be approved instead of going for liquidation, which is the last recourse on the failure of resolution process. For the aforesaid reason, we set aside the impugned order dated 18th December 20 and extend the period of resolution process for another 90 days to be counted from today. The period between 181st day and passing this order shall not be counted for any purpose and is to be excluded for all purpose. Now, the AA will proceed in accordance with law. The appeal is allowed with the aforesaid observation, no cost. So, in this case, a enclave has allowed the appeal and passed the order for extension of CIRP period by 90 days. Whether RP can be treated as occupier of the factory? I put a question before you, whether RP can be treated as occupier of the factory.
I think no, he's not a director, whole-time director of the company.
You are right. RP is not a director, not a full-time director, but Delhi High Court held that yes, he will be treated as occupier because he possesses the complete power. I am coming to only concluding part. In JK Industries case, it is held that only director can be occupier. Supreme Court has held that only director can. But since power of the director has been suspended, so who will be occupier? So this question came before the Delhi High Court. The expression used in section 17 of the code explicitly says that RP, registered professional, is the person who is vested with absolute control of the corporate debtor. While so, the violation or omission in the factory premises, registered professional is responsible for the proceedings, if any, initiated against the registered professional under the Factories Act in his capacity as occupier. The said proceeding will not be covered under section 14 or 233 of the Act. So, moratorium will not applicable here.
Personal capacity mein is actually being used.
Yes, RP will not immune. RP is not immune from section 14 or 233. Do you know 233?
I think this is now more dangerous to the RP. He has to take more care.
Yes.
Factory, yeah. Factory. There are no more number of units in a company sometimes.
Production of action taken in good faith, section 233. So RP cannot take the benefit of section 14 or 233. 233 says the production of action taken in good faith. No suit of prosecution or other legal proceedings shall lie against the government or any officer of the government or the chairperson, member, officer or other employee of the board or an insolvency professional or liquidator for anything which is done or intended to be done in good faith under this code or the rules or regulation made thereunder. So anything done, any action taken in good faith, RP or liquidator shall not be responsible. But this immunity is not available in case of violation of Factories Act. So RP shall be straightforward dragged as an occupier. The last point for consideration is whether non-consideration of the reply by the respondent will vitiate the trial. The opportunity of being heard. The opportunity of hearing is undoubtedly a right vested to the person which cannot be deprived, even if the statute does not explicitly provides for the hearing. So, in any proceeding, any hearing, right to hear is the fundamental right to all citizens of India. The right of hearing is the foundation of natural justice. Mathan Rao's case judgment principle hand. Now come to operative part of the judgment. With the above observation, the petitioner disposal, the personal appearance of the petitioner during the hearing will be dispensed except accordingly criminal will be disposed of no cost. So here the right of hearing foundation will by the time deficiency defect. Therefore, this is not a case of denial of right. Stated the learned council for education. So here Delhi High Court has held that since RP or IRP is vested with complete power, absolute power of the board, absolute power of the CD, so he will be treated as RP. He will be treated as occupier of the factory. Now question answer, any question we can discuss? Just a moment.
Sir, may I ask one question, sir?
Please, sir.
Sir, regarding the check issued before the commencement of CIRP, if the CD deliberately issued the check knowingly, it is likely to go under the insolvency. Subsequently, he informed the concerned creditor person the check. Okay, it is not a connivance between the CD and the creditor.
Can you
Hello.
repeat? Can you little
Sir,
bit? Can you
you
speak
want-
little bit loudly, please?
Sir, check issued before the commencement of CIRP.
Okay.
The creditor presented the check after that, after the
Oh.
commencement of CIRP.
Okay.
Since the check was issued 4 days before the commencement of CIRP, the CD knowingly that our company will go on the insolvency process. Let us solve the issue by issuing the check. It is not a preferential transaction. Knowingly he has done it. CIRP
Yes.
cannot, it is 24 hours, it cannot be issued. It will take its own time.
Yes. If it is knowingly issued with intent to defraud the creditors, it is preferential transaction.
It is very difficult to prove the
Yeah,
connivance.
it varies from case to case. As I said, it varies from case to case. Intention is very important. It has to be looked whether the check has been issued in regular course of business, as Mr. Vats and Mr. Murthy said. Shall we discuss one more case?
Okay, sir, you can discuss, no problem.
I put one question before you, whether stamp duty is payable on merger. 230, 231, merger, amalgamation. Can anybody clarify whether stamp duty is payable in case of merger?
Sir, it depends upon whether the company is a wholly owned subsidiary company which is going to be merged, or it is a normal company which is not a subsidiary of the company. If it is a wholly owned subsidiary, the question of uh, the stamp duty does not arise. We have to incorporate these facts into our scheme of arrangement also. But if the companies are not the holding and subsidiary company, in that case, the stamp duty will attract and will vary from state to state, and it can be less than the normal rate prescribed. It depends upon the state, and it depends upon the our scheme of language of scheme of arrangement also.
Okay. Have you come across any case where the subsidiary company, wholly owned subsidiary company, merged with the holding company or sister concern and no stamp duty was payable? Have you come across such case?
Wholly owned, I could not understand your question, sir.
Sir, have you come across any such case where wholly owned subsidiary company merged with the holding company?
Yes, yes. There are so many
And
cases.
stamp duty and liability of stamp duty does not occur.
Yes, yes, yes.
Okay. I'm just sharing one small judgment order.
But I've not seen any case, sir. I've not seen, sir.
Just a moment. Order or code of NCLT sanctioning the arrangement scheme of the amalgamation is an instrument of conveyance and is liable to stamp duty and is chargeable as per Article 23 of Schedule 1 of the Indian Stamp Act, Tamil Nadu. It is in this important judgment. It was of this year only, 2024. On important judgment on stamp duty on amalgamation restructuring division bench of Honorable Madras High Court held that order of court tribunal sanctioning an arrangement scheme of amalgamation appended thereto is an instrument. Number one. Number two, the order sanctioning amalgamation restructuring appended by the scheme as such is an instrument of conveyance liable to stamp duty under Article 23 of the Act. and no further legislative action is necessary to bring the same within the ambit of duty. Here it doesn't say they are wholly owned subsidiary or non-subsidiary or non-system concern.
Yes, yes.
It simply is that the instrument is the scheme itself is an instrument, order of the NCLT itself is an instrument. So order of the court is tribunal is instrument. The once it is declared as instrument, the stamp duty is liable under Article 23 of the Stamp Act.
Yes.
The state of Tamil Nadu is well within the power to reduce or remit this duty chargeable under the Act to the last sentence of the notification contained in the impugned government order in so-and-so, 2019, so-and-so precedent, 0.6% of the aggregate of the market value of the shares, whichever is higher, alone is struck down and rest of the notification shall stand. 5. The instrument of amalgamation is already liable to duty under the existing provisions and impugned circular is only clarificatory in nature. Therefore, any clarification would automatically be retrospective. If the duty paid in any if the duty paid in any other state is higher than the state of Tamil Nadu, then the same has to be taken into consideration and no duty shall be payable. If the duty paid is lesser than what is payable in the state of Tamil Nadu, then whatever amount paid is to be set off and the balance duty is yet to be paid on the instrument of the amalgamation. Means set off is also allowed if the rate of stamp duty varies from one state to another state. So whatever paid, it has to be reduced. But exchequer will not allow you to withhold this stamp duty or not to pay the stamp duty because of amalgamation or merger. So with this, I conclude this session and I invite queries from you. If you have any queries, please.
So hi, this is Shalini here. I'm a resolution professional. On this last point, I just wanted to check what will be the amount on which the duty would be payable in case of a merger or an amalgamation scheme by way of an NCLT approved scheme of arrangement.
Can you repeat, please? Rate of duties.
Yeah, basically this last example, because I think many companies previously have taken the interpretation that under an NCLT approved scheme, stamp duty is not payable. But there is a clarification that it is payable because it's an instrument.
Correct.
So, but on what is the value on which it is going to be paid? Because
the value. Yeah, please. Please, boliye.
So the scheme of arrangement would have various treatments of assets, liabilities, shares, etc. So what is the value on which stamp duty would be payable as per, prima facie understanding based on this order?
See, in this order, it is not mentioned what will be the value taken into consideration while deciding the rate of the duty. The value, as I understand, that the net assets value, the net assets which has been transferring to the transferee company. So on that value, stamp duty will be payable. As per my understanding.
Got it. Understood.
And
at least that's one indication. Yeah, that's one indication. Understood. Okay.
And the rate of duty varies from one state to another state. If two companies are situated in different states, then stamp duty paid in one state shall be set off against the another state if duties is lesser than in previous state. That is the transferee company state. So we will have to look into that point of view also.
Yes, that part is clear. That part is very clear. Thank you.
Thank you. Anjali ji, I think there is no other queries.
Okay, can you conclude, sir?
I think if anybody has any query, I think there is no other query. You can conclude, please.
So thank you very much, sir, for such a wonderful session and for making the interactive. And sir, you are requested to please share if you can share any material with us.
Yeah, sure. I will share this the queries, question, answer, and thereafter I also share in the zip file the judgments.
Sure, sir.
Okay. Thank you very much. Thank you, Anjali ji. Thank you, ICSI, IIP, and thanks to all participants for listening me patiently. And have a nice day. Have a nice evening. Good night. Bye bye.
Thank you so much.
Alok ji, you want to say anything? You.
Thank you, sir. Thank you very much.
Okay. Thank you.